seated.
Good afternoon, Your Honor.
Good afternoon. Okay.
Your Honor, during the break, we submitted to the court the Law&Crime URL for Mr. Jones' press conference that took place outside the courthouse. And what we, first of all, let me inquire, has the court had the opportunity to review that? And I'll also say we intend to submit a copy on a flash drive. And we understand that there's sometimes an issue with URLs and becoming part of the record.
Did you submit it as an exhibit?
We did not submit it as an exhibit, Your Honor, given the time constraints. What we did was provide the URL by email to Attorney Ferraro with a copy, of course, to Attorney Pattis.
Right. So has Attorney Pattis seen it?
Attorney Pattis.
I have not.
Okay.
I was just alerted that it was sent.
Is there any reason? Is there anything on it that would be alarming to Attorney Pattis, do you think? I mean, do we need to watch it? We could put it up and watch it.
I just question what the need for this. There's no urgency.
Well, that's what I'm asking, but I think my concern, Attorney Pattis, is I just want to make sure that, because I heard mention of the families, given the nature of the case and counsel, that I just want to make sure that there are no issues. But if
I may have been, I may have assumed more in what I heard than was there. I thought I heard a suggestion that menacing and/or threatening comments may have been made regarding plaintiffs' counsel and/or their families. As represented to me, they're ridiculing and demeaning remarks, but not threatening remarks, or not remarks of that could lead the court, could lead a reasonable court, in my view, to have the same concerns that's issued as a result of earlier rulings. But that's what I hear.
Your Honor, I would say that we do not have, as a result of Mr. Jones's personal insults towards us and our law firm, think that there are immediate security concerns as a result of that, I would say. So if that was what was prompting some urgency from the court, I don't think that that we need to do that. What we were intending to do now when we came back into court was to inform the court that we've provided the press conference. We will do so as an exhibit so that the court can review it for the purpose of assessing whether, pursuant to its own inherent authority, it should take any action here. And that is what we've come to as what we think the appropriate approach should be.
All right. So I'll take a look at it. Attorney Pattis, is there any reason that you can't attempt to persuade your client not to voluntarily not to interfere with the jurors' oath and obligations if, in fact, there was any statement that the jurors do independent research despite the court's instructions? Is that something, as an officer of the court, that you think might not be a bad idea?
Of course not. And I don't want to make warranties and representations about what I'll say or what the reaction to it will be. But of all, the only thing that I've heard this morning that startled me was, well, two things. I misunderstood what I heard about plaintiff's counsel's family. I'm no longer concerned about that.
Okay, that's good.
And while I may professionally believe in jury nullification, I also believe in the collateral bar rule, and unless given permission to argue it, I can't. And so, I will, as out of respect for the court as an institution, I will address it with my client. But may I say the following, Judge, and I've alerted my adversaries, I'm going to say this. One of the reasons that Mr. Jones goes to the press is some of the stuff that gets reported in the press. I mean, my phone is being blown up now with claims that I said in court Jones could have testified today, but as his lawyer said in court this morning, he so badly damaged himself yesterday that he needs time away from the jury. How anybody in their right mind could listen to these proceedings this morning and report that, much less Elizabeth Williams in the New York Times, why they have her covering this case when she wrote
I don't want to go down.
Judge,
Attorney Pattis, I don't.
May I please be heard?
No,
may I be heard?
No,
because I'll do it on the courthouse steps under 3.6b if I have to.
Attorney Pattis, I have made it so clear that when I'm speaking, you have to stop speaking. You've got to you just can't push it like that. You are welcome to leave this courthouse. In fact, you're welcome. I suppose you could stay in the courtroom and say whatever you want, but when I'm on the bench and I tell you to stop speaking, you need to stop. I'm going to say this again. I don't know how I'm not making myself clear, and maybe it's my fault. I do not want to sanction an attorney. I do not want to fine an attorney. I have gone almost 2 decades as a judge and never had to do that. And I don't want to do it now. But if we have a continued problem where you're talking over me, I don't know what else to do. I've asked you nicely. I'm literally almost begging you. I have no recourse but to do that. So I'm not asking for your response, but you are certainly welcome to say whatever you would like to say when we're not on the record in the courtroom. That's your right to do so. And I know that you will abide the rules of professional conduct along those lines. I want to just get back and say this. I am responsible for what happens on the record in this courthouse, in this courtroom, and I am not responsible for any other issues. So I don't want to respond to that or go down and address any such statements. My concern was that there were safety issues, or that there were statements made to the families, the plaintiffs, or to Attorney Maddie, given that we had the issue earlier. But I am so happy that that is not the case. So I think we can move on from this issue. And I think hopefully you will use your powers of persuasion and we won't have any further issues where Mr. Jones is suggesting that the jury not follow their oath, frankly. So can we please move to the earlier filing about the curative clarifying charge?
May I be heard just because under Phillips v. Ward?
I don't think so, Attorney Pattis. I'm not giving you the opportunity. It's not a give and take here. I've said what I've said, and I think that is all I'm going to do on the topic. So are you prepared?
I'm begging you for an opportunity.
No, not at this, Attorney Pattis, no, I'm sorry. Do you want to be heard on your, the curative charge now?
I have one more issue to raise with regard to the press conference, Your Honor.
Well, I'm not giving Attorney Pattis any further opportunity to address it. I think there's nothing at this point that I need to do. If you disagree, I encourage either or both of you to file something in the file, and I will make sure I read it over the weekend, okay? All right. So, Attorney Pattis, have you had an opportunity, given all these other issues, to look at this proposal on the curative charge, or is it something that we should address Tuesday morning? I don't think there's any urgency right now, but I'm happy to do it if you're both ready.
Your Honor, I'm sorry to speak over you.
Attorney Pattis?
I have.
Okay.
My preference would be to take this up Tuesday morning.
Well, if Attorney Pattis is ready, honestly, I'd rather at least cross this off the list.
Sure.
All right.
Your Honor, so during Mr. Jones' testimony yesterday, he repeatedly and in non-responsive ways indicated that he had not said the plaintiff's names with the exception of Robbie Parker. We didn't have the transcript yet, but what we did is reviewed the video and quoted for the court 3 times, at least when that happened. That raises some significant concerns, especially given how intent Mr. Jones appeared to be on getting that into the record. It's going to be clear to the jury that is a signal about how the case is going to be defended and would raise some questions in the jurors' minds. And so what we're asking for is some guidance for the jury.
Can I just back up?
Yes,
You know, I don't have all my notes right in front of me, but I recall that there were a lot of questions about which family members did you refer to as actors, and so he gave his answer, right?
There were questions initially about Mr. Aldenberg and whether he had specifically named Mr. Aldenberg.
Right, I understand that, but
Right.
he was asked the question about who did you
Right.
name as actors, and
Right.
he only recalled the one
So-
name. So he was asked about names.
He was asked whether maybe that was the question. Yeah,
Maybe
Attorney Matty's going to cover it because he's got the exact example.
This first arose early in the morning with Mr. Aldenberg, not because I asked whether he named him. I was showing him what he had put up on InfoWars, and that he volunteered.
Yes, there was some gratuity. I understand that.
And then
Okay.
the next time it came up was in connection with the defamation complaint that he brought, and he volunteered on numerous occasions during that section of the examination that he brought it because the Young Turks had named him by name, which he hadn't done to our clients.
Right.
So then that was the second time he did it. Then the third area I think that you were bringing up had to do with me presenting him with evidence that he had referred to actors in the plural, and him then claiming, and I believe the transcript will bear this out in a non-responsive format, but I didn't say any names. So I think the way the testimony came out in whole was that he was repeatedly injecting this idea in a way that was non-responsive. May there have been questions late in the day about, him saying, I would say you named Robbie Parker, and he would say, but I didn't name anybody else. I think it seemed to me that it was all him volunteering this type of thing. So that's how the day went, and I stood up because since I was the one doing it, I think that's accurate.
Attorney Pattis?
I think that is an accurate representation, and that's how I recall today. There was no motion to strike made. In fact, rhetorical use was made of it in the continued cross-examination. I don't believe there's a need for a curative instruction at this point. I believe that the instruction may be appropriate, but in the final case, if we're going to get into ad hoc curative instructions, I would ask that I'm going to be invited to file something as to Attorney Matty's suggestion in his closing or his cross-examination, the final peroration, that there's going to be another mass shooting, suggesting to the jury that compensatory damages has anything to do with that. And so we just can't get into a tit-for-tat kind of curative instruction contest here and get out of here in 2022. And I would suggest that the issue be deferred for the final charge conference when the court can see the case as a whole and see what's necessary to assure that justice is done here.
Right. So I am going to, did you want to respond briefly?
I did, Your Honor. I mean, we put it before the court for a reason. If Attorney Pattis wants to make a record and request an instruction, then I assume he would put that before the court, and he hasn't done that. And this is a posture where it's easy. I don't want to say it's easy, but the jury could misinterpret the situation. Confining the inquiry to damages is important, and so some guidance here is very important.
So I agree with Attorney Pattis on this. I think I'm going to deny it without prejudice at this point. If it continues gratuitously or not during his direct or cross when he's called at the end of next week, you can raise it again. I would also consider it for the final charge to make it clear, because I know they understand it's a hearing damages. We've said it so many times. But I understand that if it's said enough, they might be confused that even though it's a hearing in damages, your name still has to be mentioned to recover. So I'll deny it without prejudice. Hopefully it's not an issue again. If it is, you'll renew your motion. All right?
Yes, we will, Judge.
Anything else for today?
No, thank you. Have a wonderful weekend.
Judge, I'd ask you to reconsider my Phillips v. Warden claim.
No, I am not, but I decline to do so. Okay, have a nice, safe weekend, everyone.
Thank you, Your Honor.